Our next speaker, I'm very pleased to introduce, we're delighted that he could join with us, is Donald Kilmer, Jr. Don received his JD from Lincoln University Law School in San Jose. Among his legal cases, he successfully prosecuted a federal civil rights suit against Santa Clara County, as Steve mentioned, arising when gun shows were banned at the county-owned fairground. This suit was a companion case to Nordyke versus Santa Clara County that went to the Ninth Circuit. With Don Cates, I guess you did that together, right? Is that right?
No, Don wasn't with me.
Okay. Anyway, this is on commercial free speech issues. He's also been prosecuting a federal civil rights suit, Nordyke versus King, against the county of Alameda, where we are, that arose when the county similarly sought to ban gun shows at the county-owned fairgrounds in Pleasanton. And so Don is really a key person in the legal battles that we're discussing. Don?
First, thank you to the Independent Institute and David for inviting me here today. Sitting on a panel with Stephen Halbrook is like a kid who grows up watching their favorite baseball teams, and he gets to sit down with Mickey Mantle or something like that. Stephen's been a hero of mine for a long time. I guess I was asked to speak about the future of constitutional litigation involving the Second Amendment. But I guess I'm really going to talk about both the past and the future, because the Nordyke versus King case has been going on for 11 years now. I'll give you a quick update on that. The case went on Bonk after the decision came down last year in April of 2009. Neither side asked for en banc review. An en banc review is a procedure whereby after a three-judge panel makes a decision, the entire court takes a look at the decision because somebody feels they got something wrong. Normally, en banc review is a result of the parties asking that the case be relooked at. In our case, neither side asked the court to relook at the case. It came about as a result of a judge on the circuit requesting an en banc vote. It went to the entire 26 judges, I think, and there was a majority vote to have it reheard. And the procedure in the Ninth Circuit is for just 11 judges to look at it. We rebriefed the case. We argued it in September of 2009. And while we were arguing the case, the petitions for review in McDonald were pending. So the Ninth Circuit kind of punted and said, well, we'll wait and see what happens with McDonald. The McDonald petition was granted, and the rest is somewhat history. The McDonald case went up and was argued. The decision in McDonald, of course, affirmed the original three-judge panel in Nordyke. They did a due process incorporation analysis. So now that the Second Amendment does apply here in the state of California, it's somewhat of a unique legal trivia question or trivia answer, because California does not have a right to keep and bear arms in its state constitution. I believe California, Iowa, Maryland, New York, and I believe Illinois and New Jersey. I mean, no, not Illinois. Yeah. They have one, but it doesn't matter. Sort of like Hawaii and Massachusetts. In any case, there is no right to keep and bear arms in the state constitution. And the California Supreme Court, in a decision, Kassler versus Lundgren in 2000, made that a central point in their opinion when they refused to strike down the California assault weapon ban on equal protection grounds. Paraphrasing, the California Supreme Court said, because the right to keep and bear arms is not a fundamental right under the federal constitution, nor is it a right secured by the state constitution, there is no equal protection cause of action for people to complain about with regard to the different kind of rifles they own. Of course, anybody familiar with firearms understands that assault weapon is a slick marketing term. It doesn't mean anything. It's just there are different kinds of rifles. Some of them look mean. They're black. They've got flash hiders, collapsible stocks. And some of them look like Grandpa's hunting rifle, but they all function the same. So the point of the Kassler case was to try and bring a cause of action saying, look, this is an equal protection issue. You're criminalizing the conduct of some people. You're not criminalizing the conduct of others. Well, one of the nice things that'll come out of the McDonald case, sometime in the future, without giving away litigation strategy in a public forum, is hopefully somebody will challenge the assault weapon statute again, and this time say, well, now it's a fundamental right, and being as that the court already found that there was an unequal, what appeared to be an unequal application of law based on frivolous or non-important features, that maybe we'll get a different rehearing or a different result. We'll see what happens. The Heller decision is kind of special to me in one interesting way. A lot of people, mark events in their life as to what happened to them when a certain thing took place. Well, I was actually in Pasadena arguing an en banc decision, or an en banc case in front of an 11-judge panel on the Fourth Amendment, on the morning that Heller came down. Now, there were some facts. It was a civil rights case involving the Fourth Amendment right to be free from unreasonable search and seizure. And in that case, it was, I believe it was Fisher versus San Jose. In that case, Mr. Fisher had holed himself up in his house, saying he had a right to keep and bear arms. He didn't want the police, storming his house, told him to get off his land. In the case, it was interesting. Mr. Fisher hadn't committed any crime. Unfortunately, he was drunk when he was handling his guns. But although it's stupid to handle firearms when you're under the influence of alcohol, it's not illegal. So we brought a suit claiming that the police exceeded their authority by basically storming Mr. Fisher's house, using various explosive devices and water cannons and tear gas to drag him out of his house. Well, we won the case on the initial round, and the case went on Bonk. So there's some tangential issue about guns, but it wasn't a gun case. So on the morning that the Heller decision came out, I knew it had come out because I was watching my computer while I was getting ready for the arguments. And I appear in front of the 11-judge panel. And Judge Alex Kaczynski looks at me and he looks at opposing counsel. And he says, I can never tell which lawyer is representing which party. And I think Judge Pregerson looked at him and says, look at the one with the ponytail. He's probably representing the defendant. So everybody laughed about that one. And then Judge Reinhardt made a comment about, well, we know that turns out Mr. Fisher, drunk old Mr. Fisher was right, because Justice Scalia said in an opinion this morning that the Second Amendment is a fundamental right, or it's an individual right, so it turns out Mr. Fisher was right. We should just dismiss the case and send him home. Judge Reinhardt actually ended up agreeing with me on that case, but we still lost the decision 6-5. But anyway, so I have this special little anecdote that I deal with the Heller decision. In any case, after the Heller decision came out, we had been litigating the Nordyke case for eons, it seems now. Initially, we filed the case, and it was a preemption case. We made the argument that California already sufficiently regulates gun shows. There was the Gun Show Enforcement Act of 2000. We also made a First Amendment argument that gun shows are quintessential gatherings of people who are meeting for a common culture and for a common message to support their right to keep and bear arms. Well, initially we lost that issue. However, there was a footnote in the decision by the original 3-judge panel that, well, this is a facial challenge to the ordinance. We don't know what would happen if the plaintiffs did an as-applied challenge. Everyone thought the case was over when we lost, and we were sent back to the trial court. And so I filed a motion to amend, saying, well, I want to make an as-applied challenge now. So we made an as-applied challenge, and we got to summary judgment. And again, we lost. So I don't know why anybody wants any legal advice from me. I've been losing this case for 11 years. In any case, then the Heller decision came out. Kudos to Mr. Alan Gura. He saved my case twice now. The Heller decision came out and said, yeah, the right is fundamental, and it's an individual right. You don't have to be a member of a militia. However, we still had the incorporation question to go. Well, of course, the barrier to my 3-judge panel finding that the Second Amendment was incorporated was the case that Mr. Halbrook lost earlier. But he didn't really lose it, okay? He just simply laid the groundwork for me to kind of like kick it through the uprights, because he already made the touchdown. All I had to do was point out that The reason that he lost was because the original three-judge panel in Fresno had a false premise. Heller fixed the false premise, and that's how the three-judge panel in my case found that the Second Amendment applies to the states. The whole point of the 14th Amendment, and if you haven't read this book, I encourage you to do so, is that the whole point of the Civil War amendments, the 13th, 14th, and 15th Amendment, was to prevent the apartheid that eventually did happen in the South. The Reconstruction Congress made a pretty good start at trying to right the wrongs of slavery. Unfortunately, the Cruikshank decision and later decisions after that kind of undid what the 14th Amendment was supposed to do, and there were another 60 or 70 years of oppression and virtual apartheid in the South until the 60s and 70s. Finally, we have vindication in the McDonald case. And if you read the decision, or if you're inclined to only read part of the decision, which I don't know why you would be, but if you're only inclined to read part of the decision, I encourage you to read Justice Thomas's concurring opinion. It is perhaps the most magisterial thing I've ever read that the court has done. It's almost like you wrote his opinion for him, Steve, and he kind of cribbed from your book here. In any case, the future of litigation in California, I'm somewhat circumspect because we don't want to give away litigation strategy. I work for quite a few public interest foundations, CalGuns Foundation being one of them. With CalGuns' help, we have been doing a lot of field work, so to speak. We've been getting a lot of criminal convictions either dismissed or overturned. We've been doing some appellate work already, trying to help define the standard of care or the standard of scrutiny that the Second Amendment should be applied to. We have a case pending in the California Court of Appeal right now dealing with what must a government prove to take guns away from somebody when there is an allegation that they are a threat to themselves or others. No longer are counties and cities going to be able to just come in and take guns without having to prove anything. They're going to have to go through a vigorous due process right. We've also have some cases pending in federal court. I'm honored to have Alan Gurr as my co-counsel on a couple of cases out in the Eastern District, challenging California's unsafe handgun list. The list is completely arbitrary in California. There are guns that are approved for sale in California, and then there are their exact duplicates that are the wrong color that are not approved for sale in California. There are right-handed versions that are for sale, but the left-handed version isn't. So California is going to have to do some work to show that there's even some kind of important or even hopefully a compelling interest in having a list of guns that seems to be, on first blush, arbitrary and capricious. A somewhat more controversial issue has to do with the carry permits. A lot of people keep talking about concealed carry permits. Well, if you read the Second Amendment, it says keep and bear, okay? And that means theoretically you should be able to carry a gun anywhere you go. I mean, if the right is to carry a gun for lawful purposes, and one of the primary rights recognized is the right of self-defense, you don't lose the right of self-defense when you cross the threshold of your home. Now, California may have a public policy wherein they want to state, well, yeah, you can carry a gun, but we prefer that you carry concealed. And if you're going to carry concealed, we'd like to make sure that you're not a bad guy. That's probably going to pass constitutional muster. That's probably going to pass some form of scrutiny that a court's going to put to it. What probably won't pass is the completely arbitrary and capricious way that permits are handed out now, and that's basically by sheriffs and police chiefs. There doesn't appear to be, based on the research we've done, doesn't appear to be any rhyme or reason to the way these permits are handed out. People with restraining orders against ex-lovers and ex-spouses are told, well, your restraining order is kind of like a permit, but it isn't really. It's an affirmative defense if you're charged with carrying a weapon. The only way in which you can avoid an arrest is if you actually have a permit. So hopefully we'll get the sheriffs in line. There's a case out of San Diego that I'm not personally involved in where a district court judge down in San Diego made a specific finding that the San Diego Sheriff's Department appears to be engaged in some unconstitutional conduct. Future litigation with regard to the right to keep and bear arms will include pretty much a lot of procedural issues. So it's kind of a, I guess it's a precursor or a hint that it was incorporated under the Due Process Clause. But there are a lot of laws in California that don't appear to recognize any constitutional limitation on the process for taking guns away from people. For example, in the state of California, if the police appear at your house because there is a disturbance, this is Penal Code Section 12028.5. If the police appear at your house for a domestic disturbance, even if they don't make an arrest, under statute they're entitled to take any guns that they see. Okay? Now, there is a procedure in the statute by where you can petition to have the guns returned to you, but theoretically the government can prevail on the case if it can make a showing that, to do so would be a danger to anybody in the household. Well, that might make sense if somebody was arrested for domestic violence and the guns were taken as evidence and they need to be kept by the government. But if there's no charges pending and it was just a loud argument between a husband and a wife, I don't know if I want a judge deciding that he's going to start deciding who can and can't have a gun based on what he thinks is right. And it certainly shouldn't be by a preponderance of evidence if the theory is, a danger to yourself or others or something like that. So those are some of the areas that are going to be fruitful ground for litigation. California is a target-rich environment. There's a lot of stupid legislation in this state. There's a lot of cities and counties who think that they have the power to pass any law they want to. I know that Chuck Michel down in Southern California has got a cottage industry and sending out pre-litigation letters. So keep your eyes and ears open. I mentioned them earlier. Cal Guns is a great source on the web for developments in California law. I don't think you have to be a member or anything to look at their website. With that, I'll turn the podium back over to you, David.